Hi, my name is William Mays, and I am a Michigan DUI defense attorney. I have been doing this for 27 years. So I know a thing about drunk driving here in the state of Michigan. And I was watching a YouTube video the other day where a young man said to a judge that I practice in front of regularly, he was trying to represent himself. He said, "Judge, I watched 26 YouTube videos to prepare for this hearing today." And the judge, oh, no. He was arguing with the judge. And he was not making a good first impression in front of the judge. And the judge told him, don't watch YouTube videos to try to get legal information regarding a case. And I thought, you know what? I have seen a lot of bad information on YouTube from attorneys that just, it doesn't comply with the law. I've got a lot of experience doing this, and I'm going to try and walk you through from start to finish what happens with a Michigan drunk driving case. If you want to represent yourself, or if you want to go with a public defender, or you want to hire a criminal defense lawyer, I'm going to go over the highlights with you so that you understand what you're looking at. So it starts off with you being arrested, right? You've never been arrested before in your life, probably. A drunk driving arrest is a real scary thing. I've got all sorts of advice on minimizing the impact of what you can do and what your legal options are on the side of the road. We're not going to talk about that for purposes of today's video. We're going to focus in on what do you need to do right now, because you've already been arrested. You're watching this video now to get that sort of information so you know what you need to do. First things first, getting out of jail, right? I can't tell you how often I get calls from a spouse, a loved one, late at night. My husband's been picked up. How do I get him out of jail? How do I bail him out of jail, right? For the most part, the vast majority of drunk driving cases, a person is chemically tested, whether it's breath or blood, and they are released within just a few hours, with or without criminal charges. They might have a ticket that says, hey, you've got 14 days to appear in the local district court to answer to the charge of operating while intoxicated. They might just release the person if it's a blood draw with no charges, and a lot of time might go by. You might want to be careful if too much time goes by, because videotapes and body camera videos, they might disappear after a period of time. So you might want to talk to a lawyer if it's going to be lingering without criminal charges for a while. But again, majority of cases, they just release you with a ticket or with a notice to appear in the court within X number of days, at which time you have time to get your car, you have time to talk to lawyers, figure out what's going on. If the police are going to keep you in custody, though, they only have 48 hours to arraign you. A drunk driving case is a warrantless arrest, and the United States Supreme Court has held that if you are subject to a warrantless arrest, you are entitled to a probable cause determination within 48 hours. In other words, your further detention must be justified by a judge or a magistrate who signs off on it. Now, in some states, this is just a simple form that's submitted to the court, but in Michigan, we don't do these, all right? It's either a true arraignment in front of a judge or a magistrate, where the judge or magistrate reads off the charges and says, how do you wish to plead, to this criminal offense? They're required to read off the charge, provide you with notice of what the maximum possible penalty is, and then ask if you plead guilty, not guilty, or stand mute. Always plead not guilty or stand mute. Do not plead guilty at this early stage. Most judges won't even allow it. They want you to talk to an attorney, or they want you to talk to the public defender, or maybe even the prosecutor, because prosecutors will oftentimes drop a drunk driving charge down to an impaired charge. Not that that's a big victory. It all counts as a drunk driving. Police departments will frequently tell you, no, we have 72 hours. That is a bunch of nonsense. They do not have 72 hours. Arraign or release within 48 hours. United States Supreme Court. They said it. Not some 72-hour policy. No. 48 hours to arraign or release. Now, if you are actually arraigned in front of a judge or a magistrate, they might impose bond conditions or pretrial release conditions. And this is problematic in some courts. A judge might say, you know what? It's going to be a $500 cash bond, and you have to be hooked up with a scram tether. That's a type of alcohol monitoring device. And it has to be done through, say, for example, the Wayne County Jail. You'll be sitting there for 5, 6, 7 days, waiting for that tether to become available before you can get released. I have objected to this practice with a number of courts. I do not believe that it is constitutional. Your job when you're sitting there in jail is to get out as quickly as possible. And for a minor misdemeanor, which enacts a drunk driving charge, a first offense drunk driving, is considered a non-serious misdemeanor under Michigan law, unless there's an accident that involves injury or damaged property. So, you should be released, and there is a constitutional presumption that you will be released without conditions and without the necessity of posting a monetary bond. Now, at an arraignment, they may have an MIDC attorney present for arraignment purposes. This is a court-appointed attorney that acts as the defense attorney for just that limited purpose of the arraignment. If you are represented by an MIDC attorney at the arraignment, they will help guide you through the pretrial release conditions. The pretrial release conditions fall under Michigan Court Rule 6.106. If you want, you can look up the Michigan Court Rules. They are available at the Michigan Supreme Court's website, and you can read through the presumption of innocence and how a person should be released on an unsecured bond or personal recognizance without conditions. Conditions, however, have become almost routine in drunk driving cases. If you are released from jail with a notice to appear within 14 days, courts will frequently waive the arraignment. Most courts will, because an arraignment is really just a waste of the court's time and the defense attorney's time, because a defense attorney can tell you, hey, here's the maximum possible penalty for this offense, and we're going to waive that arraignment. We're going to combine it with a pretrial. A pretrial is when you get an opportunity to actually address some of the details regarding the case. Now, as I mentioned a moment ago, pretrial release conditions have become very popular with a number of judges in the state of Michigan. And I think that we engage in a lot more pretrial testing than other states. As you can see what I've got up here on the screen, these are supplements that you can purchase at a gas station. Back a couple of years ago, we actually outlawed a substitute for urine that was designed to try to trick drug screens. It is still legal for the gas stations and head shops or whatever to sell detox clean that you drink. Don't try those. If you are ordered to alcohol test, don't drink alcohol. If you are required to drug test, don't do any drugs. You will not, inevitably, you're going to screw up. All that these detox supplements that you drink do is add an amount of creatinine to your urine so that if your urine is diluted and you artificially increase the amount of creatinine in the urine sample, it will appear to pass the test. But there's no guarantees. Inevitably, you'll fail one of those tests. Don't get caught on a pretrial release condition trying to fool it with something, because that just leads you in more hot water. So one of the first things you need to determine once you get out of jail is, did you refuse a chemical test? Like I said earlier, it might be months before a criminal charge is lodged against you. But if you are provided with a notice of a chemical test refusal, you only have 14 days to respond. Taking a look at the screen up there, you can see a DI-93 form. That is a refusal form, so the police are alleging that you refuse to submit voluntarily under implied consent to a breath test or to a blood test, or occasionally, a rare occasion, a urine test. The request for hearing must be sent to the Michigan Secretary of State. It does not go to the court. It has nothing to do with the court. If you don't request a hearing within 14 days, your license is automatically gone. 1 year suspension for a first refusal, and 6 points are added to your license. As an added benefit, though, because again, I've got advice that I give to people on a regular basis, but this is already behind you for purposes of this video. You've already been arrested. You're just now getting out of jail. This is what you need to be concerned about. If you refused, there's an upside to it. We can challenge that. We can conduct a full-blown hearing with the officer. We get a whole bunch of discovery through this process. I can help you evaluate the criminal charge that might come later with the Secretary of State hearing. On the other hand, however, if you didn't refuse and you've got a 625G permit that has up in the upper hand, left-hand corner, DI 177, well then great. You don't have to do anything regarding your driver's license at this time. The next thing you want to do is research DUI lawyers. Now, there's a whole lot of people. It used to be the yellow pages back in the day. There was about an inch of ads of various attorneys. I'm a DUI attorney. I'm a DUI. Everybody was falling over themselves, claiming to be a DUI attorney. It is now the same as well. I mean, there is everybody that's got a website, everybody who does a little bit of criminal law, even a whole bunch of people that don't do a lot of criminal law, will take on a DUI case. There are only a handful of dedicated drunk driving defense attorneys in the state of Michigan, despite the fact that thousands of attorneys claim to do DUI work. You want to look for qualified drunk driving defense attorneys if you want to challenge your case. You don't want to challenge your case, you can hire somebody local, or you might go with the public defender, or you might even represent yourself. A good qualified drunk driving defense attorney is going to be a member of the National College for DUI Defense. That's a nationwide organization that's been around for, about 25, 30 years, that teaches attorneys how to become more effective drunk driving defense attorneys. There's DUI DLA, another national organization that networks with other attorneys and offers them training events where they get to learn about the science and advanced legal techniques on how to effectively defend drunk driving cases. The NACDL is the National Association of Criminal Defense Lawyers. This is not, it's not especially aimed at drunk driving. It's more aimed at national criminal advocacy. But a good lawyer is going to be a member of NACDL. And NACDL has combined programs where they put on drunk driving defense seminars with organizations like the National College for DUI Defense. In Michigan, we have an organization called CDAM. That's the Criminal Defense Attorneys of Michigan. There is a dedicated training for lawyers and trial advocacy skills offered by the Criminal Defense Attorneys of Michigan. And it stands as a mark of somebody that's trying to do more than your average attorney. I was the president of CDAM a number of years ago for a year. And then there's also MyOWI, which is the Michigan organization that is, it's a smaller organization, but it is dedicated to drunk driving defense. I'm on the board for MyOWI. When you're looking for an attorney, though, there are attorneys out there that will charge a lot of money, primarily based upon their geographic region. There are certain areas of the state that just dictate a lot more money to be paid to a criminal defense lawyer. If you're going to pay good, hard-earned dollars on a qualified drunk driving defense attorney, don't buy the little beater car and paying Mercedes-Benz prices, right? If you're going to hire a good attorney, though, you're going to expect to pay a premium for a good qualified drunk driving defense lawyer. Make sure that you understand what your goals are in this case before you go off and hire a lawyer. If you're trying to figure out, hey, is this attorney a good drunk driving defense lawyer? Ask a few questions. Ask about their motion practice. How often do you file motions on a drunk driving case? How successful have you been? How often do you take a case to jury trial? There are one or two attorneys in the market in the Detroit area right now who claim to be the best thing since sliced bread, and neither one of them has ever challenged a drunk driving case. And they have remarkable Google reviews. So you need to be very cautious when you hire an attorney if you don't know what their trial record is and if they don't routinely challenge cases. DUI attorneys dedicated DUI attorneys, we go to trial a lot. We don't win them all. All right. We do not win them all, but we win a substantial number. Otherwise, we would stop practicing in this area of defense, right? But for the person that never takes a case to trial and doesn't argue motions, that's just shameful. You could go with the public defender. The public defender is there, though, to ensure that your constitutional rights are protected. They're not there to go over and above the call of duty. I had a fella call my office the other day. He had a case in a jurisdiction near my office, and he was just angry with that public defender because he hadn't called. The public defender was going to meet with him in court at his pretrial. They were going to go over the case, and I'm sure that he worked out a plea agreement. But that's typically what happens. There are a few exceptions to this. I know one public defender that really battled a very interesting case, and there was another one on the western side of the state, took a case all the way up to the Michigan Court of Appeals, where I participated in submission of an amicus brief that did a lot of damage to the drug recognition expert program. So it's not always the case that a public defender doesn't go above and beyond, but it is really the exception and not the rule. The rule is a public defender is there to ensure that your constitutional rights are protected. You can also represent yourself, of course. If you're going to go improper, though, this is dangerous territory. But if you're trying to get an impaired out of a good, decent prosecutor, more often than not, you can negotiate that on your own if that's what you're trying to do. If you're trying to play the sovereign citizen game or claiming to be a state national and I'm not by my legal name and whatever, that is just going to get you in a lot of trouble. And if you do your research and you've watched a bunch of crazy videos from these various sovereign citizens and state nationals, they ultimately fail. Some of them are even disbarred from filing frivolous pleadings without leave of court in a variety of jurisdictions. So you really want to look at that a little bit more closely if you're inclined to do that. Now, discovery is the first step in challenging a case. Police reports, logs pertaining to the breath machine. There's a huge packet regarding blood evidence that the Michigan State Produced Toxicology Unit will produce. Body cams, in-car videos, station house videos. All of this has become very routine. 20 some odd years ago, when I was practicing drunk driving defense as a young lawyer, we used to argue, hey, I want more videos. And now I've got external hard drives that are filled with videos, and it's a constant, it takes a long time to go through these materials and actually watch every single video and analyze the case. But there's a lot of stuff in there that can be really helpful for the defense. In terms of case analysis, and I apologize, this is a little small, but some of the common defenses that you'll see in a drunk driving case was the driver even operating the motor vehicle? I've got a case that's going on a couple years old at this point where I've tried to get dismissals, but my client was asleep in the car, literally not in the front seat, but in the back seat, stretched out, laying down, went to bed, just using the vehicle as shelter at night. Michigan law versus Ohio law versus some other states' laws might radically differ on this. But for Michigan's purpose, operating a motor vehicle requires a person who's driving or is in physical control of the motor vehicle, which essentially means driving or placing the vehicle in some position where it's at risk or at risk of harm or potentially risk of harm. Was the traffic stop lawful? There are a number of jurisdictions, especially on weekends, where the federal National Highway Traffic Safety Administration offers subsidies. Thanksgiving, St. Patrick's, your holidays around Christmas and New Year, where officers are paid overtime funds to work DUI shifts. And that overtime, it needs to be justified. So they're out there making traffic stops, and not all those traffic stops are legal. Did the officer develop probable cause to make the arrest? Now, probable cause is a complicated legal theory, basically, that it depends on the facts and circumstances, what the officer sees, what the officer hears, what the officer is able to enunciate, and the field sobriety tests. Now, I've got numerous videos out there about field sobriety tests. I mean, that's just one tiny little aspect. This is just a general broad brush that we're going over here today. Was the defendant properly advised of their chemical test rights? Did they submit voluntarily under implied consent? I have had clients that have tendered themselves to the test, done the test, only to find out, lo and behold, after I reviewed the case, they didn't voluntarily submit to that test. The officer thought they did. The client thought they did, but I pointed out, no, they didn't. You can get the chemical test suppressed in some cases because of an involuntary submission to a chemical test. Were the chemical tests accurate? Was it properly calibrated? Do they have the proper data to supply to you through the discovery process to establish it? And ultimately, was the chemical test accurate? I mean, there are entire jury trials as to whether or not the chemical test was accurate. Now, at a pretrial conference, this is an opportunity for a defense attorney and the prosecutor to sit down. Clients sometimes get upset because a lot of times the prosecutors and defense attorneys are friends. We catch up, we talk about other things, and some of these clients want us to fight. There are prosecutors I fight with. They're rare, though. Most of the time, I'm friends with these prosecutors. You, on the other hand, if you're representing yourself, you're not going to know this guy. Most of the prosecutors are decent people in the state of Michigan. So you can engage in plea bargaining at this pretrial conference, or it can be treated as a scheduling issue. Oftentimes, there's multiple pretrials. Tomorrow morning, I will be appearing on a case. I'm just substituting in on behalf of another attorney after the client, and that didn't work out. This will be the fourth pretrial, and there will be numerous pretrials after this because of scheduling of motions and, production of discovery at this stage. So it's not unusual for these cases to go a while. Now, when you appear in court, dress appropriately. I can't tell you how often you go into court and you find somebody that's dressed inappropriately. This is not the place to be dressed inappropriately. There was actually a judge that used to force people to leave the court if they were wearing jeans. Now, I thought that was a little, beyond and above, but you should dress in a manner that's respectful, at least business casual, at least. Be respectful, not just to the judge, but to everyone at the court officers, the prosecutor. What you say and what you do in court will be held against you, unfortunately. And so, maybe take a little page out of Winning Friends and Influencing People and try to be that sort of a person, at least for that day. Listen carefully to everything. Now, you will hear a bunch of jibber-jabber, legalese, and that sort of stuff. Don't concern yourself with that. Pay attention to the dates, the judge's rulings, what the prosecutor's specifically telling you. These things are important down the road. Understand what your rights are. I mean, I can rattle through your rights, right? You have the right. You are presumed to be innocent. You have the right to a trial by judge or by jury. You can't be found guilty unless the prosecutor proves all of the elements beyond a reasonable doubt. At a trial, you have the right to see, hear, and cross-examine witnesses. You have the right to subpoena witnesses to testify on your behalf. You have an absolute right to testify. And I can't stop you. No defense attorney can stop you, but no one else can stop you either. You also have an absolute right of silence. And if you wanted to exercise your right to remain silent, we could have the jury instructed at our option that your silence can't be used against you. And at all critical phases of the proceedings, you have the right to the assistance of an attorney. And if you couldn't afford one would be provided for you at public expense. All good. But you need to understand those rights before you can waive them, right? If you don't understand your rights, and if you don't understand the penalties, that's the next thing on my list. If you don't understand the penalties to a drunk driving, you could be in a lot of trouble. Now, let's take your typical OWI, not a super drunk, just an OWI, first offense, nothing on your record. Prosecutor offers to plead it down to impaired. An impaired carries a $300 fine plus court costs. That could tally up to $1,000, $1,500. The driver's license, if there's nothing else, no implied consent violations, 90 days restricted driving, to and from work, for work, to and from any emergency medical. But you can't pick up your kids from school, can't go grocery shopping. If you get caught driving outside of those restrictions, you look the cop in the eye and you say, oh yeah, no, I'm going to the grocery store to get milk. Don't do that. If you do that, though, it's a new criminal offense and it can be a violation of your probationary terms. But yeah, fines, driver's license sanctions. There's up to 360 hours of community service, Most courts, 40, 50 hours. You can be placed on probation, although there is a presumption of no jail and no probation for an OWI or an impaired, where there's no accident that causes injury or damage. But a lot of judges ignore that new statute. So fines, cost, community service, that you may be required to refrain from the use of alcohol. You may continue to be monitored for alcohol or drugs. Those are just some of the penalties that are there. 4 points on your driver's license. But then you start to find out what some of the other penalties are. If you're a doctor or a nurse, mandatory reporting. If you're a commercial truck driver, you lose your CDL for 1 year. If you're a commercial pilot, then you already know FAA required that you disclose it before you even went to court. There are a number of occupations and fields where professional licensing is a major concern. And there are also restrictions on your ability to travel to Canada. So if you have to go to Canada for work or you own property over there, this can be disastrous. The other penalties, if you get a second offense within 7 years, your driver's license can be revoked, and that revocation will last the rest of your life unless you affirmatively go to the Secretary of State after that second offense, get that license back. Third offense, anytime in your life, is a felony, and there's mandatory jail for a felony unless certain circumstances or there's finagling that defense attorneys might be able to do to get you into a treatment program, maybe avoiding jail. And even though the third offense is the highest, it's a felony charge, right? First offense and second offense are both misdemeanors. Once you get into the felony region, there are judges that give real jail, like substantial jail, and even prison. Carries 1 to 5 in prison. So, understand the consequences of your plea, basically. So, if you're going to represent yourself, or if you're going to go with the public defender, and you're not going to treat this real serious, you don't necessarily have to, but you maybe want to think about it, right? So, appearing by Zoom. A lot of the courts are using Zoom nowadays. I love Zoom. Zoom saves me so many miles on my car and so much time in court. I can do 3, 4 different courts all at the same time, bouncing from court to court, and it's all done in a reasonable period of time. If you're going to appear in Zoom, treat it just like you are in court. Let me rephrase that. Act like you're in court. Dress appropriately. Act appropriately. Don't be lounging on your bed. Don't be laying on your couch. Make sure that you are dressed professionally, or at least, business casual. Sit still. Don't be walking around. Oh my God. It annoys people to no end if you are walking around. If you're at work and you're still working, then you haven't taken the time off and a lot to address court. The court is always an inconvenience. So I'm not suggesting you have to take the day off from work. Not at all. But you need to take that time off from work to appear in court. So get yourself a good area where you've got strong internet connection to appear via Zoom. Don't talk out of order. Keep yourself muted, but assume that you are not muted. Keep your video off until your case is called, but assume that it is still recording and still broadcasting so that you're acting appropriately. Don't eat, drink, or smoke, or wear a hat. I've got some other rules up there, but, again, just treat Zoom as if you were in court. Motions. There are so many motions that can be filed in a drunk driving case. Motion to challenge the traffic stop, motion to challenge the probable cause, motion attacking the little fancy eye test that the cops use, a Walker motion to challenge the admissibility of statements, a motion to suppress the breath test, a motion to suppress the blood test. There are a lot of motions that can be filed, but really at this point, you need a qualified attorney if you're going to challenge a case through the motion process. These are like mini trials, though. An evidentiary hearing might be conducted where an officer has to testify. These are some of the techniques that can be used, though, to win a drunk driving case. Jury trial, of course, if you are going to try and represent yourself at a jury trial, the court is under an affirmative obligation to caution you against it. Jury trials are usually well beyond the abilities of your average everyday person. because there's complicated rules of evidence that need to be followed. People think they don't understand how exhibits can be introduced. It can be a difficult process, and the judge is not allowed to actively assist you. So I discourage people from representing themselves at a jury trial. Criminal appeals are available in drunk driving misdemeanor cases. This could be an appeal of right after you've lost a case, right? Where you have X number of days to file your a claim of appeal with the circuit court, or there could be an interlocutory appeal, which is an appeal that's permitted by leave of the higher court, but it might be done after you lose a motion hearing, for example. The circuit court, although that's a trial court for felony cases, sits as the appellate court to the district court. I have serious questions about it because the circuit court judges are trial judges. I don't really feel that they're well suited to act as appellate judges. I wish that we could modify our court rules so that any appeal from district or circuit went to the Court of Appeals. But it's designed in this fashion to alleviate some of the pressure on the Court of Appeals. So you have to go through the circuit court for your initial appeal. And if you win great, but more often than not, circuit court is, in many instances, a rubber stamp on the way to the Court of Appeals. If you lose in the circuit court, you are allowed, though, to file an application for leave to appeal in the Court of Appeals. And above the Court of Appeals, the Michigan Supreme Court. If you are found guilty, or if you plead guilty, then you have to do the probation interview. This is mandatory. This is written into our drunk driving laws. It's in the statutes. A judge is not supposed to sentence somebody without this pre-sentence investigation, probationary interview. Normally, in most courts, this consists of the needs assessment survey, which is a multiple choice questionnaire. I help my clients with that needs assessment, teaching them what some of the trick questions are. And then there's a face-to-face interview with the probation officer. You treat that like a business meeting. It's not church. It's not confession. But there are certain things that the probation officer wants to hear from the probationer to ensure that they've learned something through this process. After that is completed, a report is generated by the probation department to go to the judge. And then the judge can sentence you. Now, there is that presumption of no jail and no probation that I mentioned earlier, but some judges are not following it. You got your fines and costs. You will likely be ordered to refrain from the use of alcohol if you are given a probationary term. You will be given credit, halftime credit, under this new statute that says no jail, no probation, that some of the judges are ignoring. You are entitled to halftime credit. So if a judge gives you 2 years of probation, you're entitled to be off at 1 year so long as you've satisfied all of the requirements. And all the courts that I'm familiar with are following this rule so that if you are doing everything right, you can get off probation early. And a lot of the judges are giving 3 months or 6 months where you're off probation in a relatively short time frame if you do everything that you're required to do. I suggest to everybody you pay your fines and costs off at the day of sentencing. Most of the courts will do a payment plan, and I know that it's painful to pay it all off in one fell swoop. It is the best practice, though, because it gets that out of the way. Many of the courts are ordering that people refrain from the use of marijuana, and this is contested. First off, if you've got a medical marijuana card, there is a case from the Court of Appeals that says you're allowed to use it on probation, period. But there's also the Michigan recreational marijuana law that we passed, and it makes no provision for the district court to prohibit a person from using marijuana while on bond. And now I know what you're thinking. You're thinking, but it's just like a judge tells me I can't drink alcohol. No, it's not. Because we don't have a law that affirmatively states you are allowed to drink alcohol after the age of 21 and no one can stop you. We don't have that for alcohol. We don't have that for Coke versus Pepsi or anything else, right? But we do have this law that says if you're over the age of 21, you're allowed to use marijuana and no one can stop you. So that is an issue that I think is going to percolate up through the courts on an appeal basis. And I think ultimately that unless they change the law, it is legal to use marijuana. Now, don't do that in contradiction of the judge's ruling, but you can file a motion to challenge any prohibition against using marijuana. Community service, like I said earlier, it's up to 360 hours, but 30, 40, 50, 60 hours, that's a solid week's worth of work though, right? So that is a significant amount of time. There can be counseling classes. You might be required to go to an alcohol counselor. It's not necessarily a bad thing if there is a substance abuse problem. Some courts do order AA, but that's very rare. Most of the courts are not ordering AA, mainly because it's supposed to be a voluntary organization. It's supposed to be anonymous. And some people don't find it particularly beneficial. If you like AA, then wonderful. Good for you. By all means, I encourage you to do it. But if you don't, or if it just doesn't suit you, then, I think there's other alternatives. Lastly, jail. I mean, I can't tell you how many times I get a call. People are terrified of going to jail. Of course you are. That's reasonable. Most people in most courts don't go to jail. There are a few judges out there that have a policy where they are putting people in jail. And those judges, if they're not following that statute, I have a real problem with that. But the vast majority of judges do not order jail unless there's a probation violation. Now, if you violate probation, the gloves can come off and the judge can punish you for that. So, and once you've pled guilty, there's only so much that a defense attorney can do for you on a violation hearing. That's the end of my presentation. I've been trying to work on the quality of these videos to get them up to par so that they look a little bit better, they sound a little bit better. I intend to produce more videos in the future. So, drop a like, subscribe if you like, and I intend to put out some more videos in the near future. And thanks for watching.